American citizenship, something millions consider permanent, is no longer guaranteed in every situation. For decades, a U.S. passport represented finality. Once you became American, that status was protected for life. But today, a new and deeply significant conversation is unfolding across immigrant communities, and it's one that naturalized citizens cannot afford to overlook. Welcome to U.S. Policy Brief, your reliable source for the newest information on U.S. immigration, visas, green cards, and citizenship. I am your host, Daniel Brooks. In this video, we break down important developments you need to know clearly, accurately, and without speculation. There are more than 26 million naturalized citizens residing in the United States today. People who legally immigrated, met every requirement, and swore an oath of allegiance to this country. Many have lived as Americans for decades. They've raised families, built careers, paid taxes, voted, and fully integrated into American society. Yet, recent developments suggest that citizenship for some may now face renewed examination in ways we haven't witnessed before. Immigration enforcement in the United States has traditionally centered on borders, visas, and who is permitted to enter the country. But what's emerging now represents a fundamental shift. The focus is no longer just on admission. It's increasingly about who gets to remain American. Internal guidance circulating within U.S. Citizenship and Immigration Services, commonly known as USCIS, signals a far more aggressive approach toward reviewing past naturalization cases. According to this guidance, immigration field offices have been instructed to actively identify a significant number of cases each month that could potentially qualify for denaturalization, the legal process of revoking U.S. citizenship. These cases may then be referred to the Department of Justice for further legal action. For many immigrants, especially those who believed citizenship was the final chapter of a long journey, this represents an unsettling change. And as we move closer to 2026, the implications of this policy shift are becoming impossible to overlook. To understand why this moment is so significant, we need to examine closely at the numbers. Denaturalization has always existed under U.S. law, but for decades, it was treated as an extraordinary measure, used sparingly, and only in the most extreme situations. Historically, this process was reserved for circumstances involving clear, intentional fraud or serious national security concerns. But internal directives now circulating within U.S. Citizenship and Immigration Services suggest a dramatic change in approach. Immigration field offices across the country have reportedly been instructed to identify between 100 and 200 potential denaturalization cases every single month. Once identified, these cases can be forwarded to the Department of Justice for possible prosecution. Let's put that into perspective. Over roughly the 8-year period starting in 2017, the total number of denaturalization cases filed nationwide was about 120. That averages out to roughly 15 cases per year across the entire United States. Under the new guidance, however, the numbers change dramatically. Even at the lower end of the target, 100 cases per month. That translates to 1,200 cases per year. At the upper end, the figure could reach 2,400 annually. That's not a small increase. It represents a shift of nearly 100 times compared to historical averages. What was once a legal rarity now risks becoming a routine enforcement tool. This is where concerns begin to intensify. Denaturalization was designed by federal law to be rare, precise, and evidence-driven. But when numerical targets are introduced, the incentive structure changes. Officers are no longer simply responding to the most obvious situations. They are now under pressure to actively find them. Legal experts and former immigration officials warned that under this kind of quota-driven environment, the threshold for what qualifies as a serious issue may gradually erode. Minor inconsistencies, long-forgotten details, or paperwork discrepancies that once carried little significance could suddenly be elevated into grounds for life-altering legal action. And for millions of naturalized Americans, that reality is what makes these numbers so deeply unsettling. Under U.S. federal law, stripping someone of their citizenship is supposed to be extremely difficult. Naturalization, once granted, is meant to be permanent, except in very limited circumstances. Legally speaking, denaturalization can only occur if the government proves that citizenship was obtained through intentional fraud or by concealing material facts during the application process. This includes knowingly lying, deliberately misrepresenting information, or securing citizenship through illegal means. Honest mistakes, memory gaps, or minor clerical errors were never intended to qualify. But that distinction is critical. The law draws a clear line between deliberate deception and human error, and for decades that line served as a safeguard for naturalized Americans. The concern now, according to immigration attorneys and former officials, is not that the law has shifted, but that how it's being applied may be shifting. When enforcement agencies operate under monthly numerical expectations, the definition of what counts as material can begin to stretch. Small inconsistencies that once would have been corrected administratively may now be reframed as evidence of intent. Former officials familiar with internal review processes warned that many naturalization applications were filed 10, 15, even 30 years ago. In many situations, applicants were completing complex forms in a second or third language, often without legal counsel. Dates, travel histories, past addresses, or employment timelines may not have been perfectly documented, but that does not automatically mean there was fraud. Here's where this becomes deeply personal. Imagine becoming a U.S. citizen after years of waiting, then living as an American for decades, working, paying taxes, raising children, and fully contributing to society. Now, imagine that an old application is pulled from an archive, reviewed under a modern enforcement lens, and scrutinized line by line. A forgotten short trip, a misremembered date, or a slightly different description of past employment could suddenly be reinterpreted as a serious misrepresentation. Under a system that prioritizes volume, critics argue the risk is that intent, the cornerstone of the law, gets replaced by technical interpretation. And for naturalized citizens who believe their journey was complete, this possibility introduces a level of uncertainty they never expected to face. Officials defending this approach insist the goal is simple: protecting the integrity of the immigration system. Public statements emphasize that denaturalization efforts are intended to focus on individuals who, according to the government, should never have received citizenship in the first place. This includes people accused of serious criminal activity, gang involvement, financial crimes, cartel connections, or violent offenses that were allegedly hidden during the naturalization process. From the administration's perspective, this is framed as a cleanup operation, identifying past fraud and correcting it no matter how long ago it occurred. Prosecutors have reportedly been encouraged to pursue denaturalization cases as aggressively as the law permits, signaling a proactive posture rather than a case-by-case response to only the most obvious violations. What makes this moment distinct is that denaturalization is not happening in isolation. It's unfolding alongside a much broader immigration enforcement agenda. In recent years, the United States has seen tighter asylum rules at the southern border, pauses in certain asylum processing programs, and sweeping restrictions affecting entry from multiple regions of the world. All of those measures, however, shared one thing in common. They targeted people trying to enter the country. This policy shift breaks from that pattern. Denaturalization is not about borders, visas, or undocumented status. It is about people who already completed the process, already took the oath, and already received the full rights and responsibilities of U.S. citizenship. The focus has moved from who may become American to who is permitted to remain American. For naturalized citizens, this change carries a heavy emotional weight. Citizenship has long been viewed as the finish line, the moment when uncertainty ends. But as denaturalization becomes a more visible enforcement tool, that sense of finality is beginning to erode. Legal experts warn that even without mass revocations, the policy itself can create widespread anxiety. People begin to question past paperwork, second-guess long-forgotten forms, and fear that a mistake made decades ago could resurface with life-altering consequences. This atmosphere of uncertainty, critics argue, doesn't just affect individuals. It reshapes how entire communities relate to the government and to the concept of citizenship itself. To fully grasp what's at stake, it helps to examine the size of the population potentially affected. Today, there are approximately 26 million naturalized citizens residing in the United States. Every one of them was born abroad. followed the legal immigration process, and was ultimately granted U.S. citizenship, and that number continues to grow. In just the past year, more than 800,000 people were sworn in as new American citizens, believing they had reached a permanent and protected status. But under an expanded denaturalization strategy, sheer scale matters. Even if only a small fraction of cases are pursued, the psychological impact reaches far beyond the individuals directly involved. After Mexico, India is the second largest country of origin for naturalized U.S. citizens. In 2024 alone, nearly 50,000 Indian-born immigrants became American citizens, accounting for more than 6% of all naturalizations nationwide. That places the Indian-American community among the most statistically exposed to any shift in how old citizenship files are reviewed. Many Indian immigrants came to the United States on employment-based visas, particularly in technology, medicine, engineering, research, and business. They waded through long backlogs, often spending 10 to 15 years in temporary or permanent resident status before finally qualifying for citizenship. By the time they naturalized, many had already spent decades in America, raised U.S.-born children, purchased homes, and built professional careers. For these families, citizenship was never seen as conditional. It was the end of a long journey marked by rules, paperwork, delays, and patience. But denaturalization quotas introduce a new layer of uncertainty, one that didn't exist before. Immigration attorneys report that naturalized citizens are now asking questions they never imagined they'd need to ask. What if something on an old form was incomplete? What if a trip was miscounted? What if information listed on a green card application years ago doesn't perfectly match what appeared on a later citizenship form? These concerns are especially intense for people who naturalized many years ago when records were paper-based and memories were far less precise. For many, the fear isn't just about legal risk. It's about losing the sense of security that citizenship was supposed to provide. Legal experts warn that the impact of this policy goes far beyond the number of cases actually filed. Even the possibility of expanded denaturalization creates what they describe as a chilling effect across immigrant communities. Naturalized citizens may become hesitant to travel internationally, worried that re-entry could trigger additional scrutiny. Others may avoid interacting with government agencies altogether, even for benefits they are legally entitled to, out of fear that any contact could reopen old files. Simple everyday actions can begin to feel risky. Updating an address, correcting a record, or reporting a change in circumstances may suddenly feel like inviting unnecessary attention. Over time, this kind of fear can erode trust, not just in the immigration system, but in the promise that citizenship itself is meant to represent. There is also a broader concern that cannot be overlooked: fairness. If immigration offices are expected to meet numerical targets, will certain communities face more scrutiny than others? Will people from specific countries with certain names or from particular backgrounds be reviewed more aggressively? While there are no definitive answers yet, civil rights advocates argue that the risk of unequal application is real and that it raises serious questions about equal protection under the law. At an even deeper level, this debate forces a national conversation about what American citizenship truly means. For generations, becoming American was understood as final. Once naturalized, you were American. No asterisks, no conditions. But if citizenship can be routinely revisited and potentially revoked based on decades-old paperwork, does that create a two-tier system? One for natural-born citizens and another for naturalized ones. For the 26 million naturalized citizens residing in the United States today, the landscape is clearly shifting, particularly for communities like Indian Americans and other long-settled immigrant groups. The assumption of absolute permanence no longer feels as solid as it once did. Citizenship may still come with rights and protections, but it now carries a new sense of vulnerability. This is a developing story, and it deserves close attention. Experts recommend that naturalized citizens review their old immigration records, ensure documentation is consistent, and consult an immigration attorney if there are any concerns, especially before international travel or major filings. Thank you for watching U.S. Policy Brief. If you found this video helpful, subscribe to U.S. Policy Brief and hit that notification bell so you never miss an update on immigration policy that matters to you. Stay informed, stay prepared, and I'll see you in the next update.